The Parliamentary Justice and Legal Affairs Committee has indicted the drafters of the BBI referendum bill for usurping the powers of the IEBC in the distribution of the 70 newly created constituencies, while the committee in its final report holds the creation of the additional 70 constituencies was constitutional, dictating their distribution was unconstitutional. The committee submitting that 32 county assemblies debated and approved the wrong BBI bill that was strewn with a litany of typographical errors.
It has been a week of protracted negotiations for the Joint Parliamentary Committee, the end product, a majority and minority report on the BBI Bill. The creation of additional 70 new constituencies being the point of departure for the members. Majority of the Joint Parliamentary team faulting the BBI Bill drafters for usurping the powers of the IEBC in proposing the distribution of the newly created constituencies. In its final report, the committee termed the second schedule of the bill as unconstitutional in contravention of the constitutional mandate of delimitation of boundaries which is vested on the IEBC. Nonetheless, the committee holds the proposal to increase the number of constituencies by 70 was constitutional. The report reads in part, Clause 10 of the bill that proposes to amend Article 89, Sub-Article 1 of the Constitution by increasing the number of constituencies from 290 to 360 is constitutional. Nairobi Senator Johnson Sakaja penned a dissenting report stating that under the popular initiative driven by Kenyans, the creation of the additional 70 new constituencies and their distribution amongst counties as set out in the second schedule was within the powers of the people of Kenya, being the drivers of the process. Sakaja indicating the distribution of the constituencies comprised an allocation and not delimitation of boundaries, and thereby IEBC has not been stopped and will be required to conduct the delimitation exercise. Murang'a Senator Kang'ata on his part has challenged the report, having abstained from signing off on the report.
The schedule that is proposing to create new constituencies. So first, I wanted to understand the criteria that was used to say County X is going to get this number of constituencies and County X is going to get this number of constituencies. The criteria is not clear.
Meanwhile, with allegations of existence of different versions of the BBI bill, the committee has admitted that 32 county assemblies debated and approved an erroneous bill that was strewn with a litany of typographical mistakes. Only 11 county assemblies approved the correct bill, with 4 counties rejecting the bill. The committee trying hard to downplay the existence of varying BBI bills.
We had a bill where there was misprinting of Article 89(7). What appeared in that bill was 87 sub-article 7. And we have taken note of that typing error. And that affected 32 county assemblies.
Some of the bill, when it was sent, copy, had some error, a typing error. That is correctable.
43 county assemblies rubber-stamped the bill, with the threshold being only 24 county assemblies. Given that only 11 county assemblies debated and approved the correct version of the bill, as Parliament reconvenes next week to decide the fate of the referendum bill, questions abound about the legitimacy of the process.
According to the advice that we were given by the experts, we cannot amend the bill. So therefore, if we cannot amend, then what will the National Assembly consider? What will Senate consider? So therefore, us in the Senate, if we shall endorse the bill, we shall endorse an erroneous bill.
IEBC has already absolved itself from blame. The electoral agency indicating that BBI promoters delivered 6 copies of the referendum bill alongside their signatures. Upon verification of the same, IEBC said it requested and received 57 printed copies of the bill from the BBI promoters, out of which it transmitted 47 of the same to county assemblies. Samogina, Citizen TV, Nairobi.